I'm going to introduce Will Simmons, who is the District Court Administrator for the 6th Judicial Administrative District Superior Courts of Georgia and currently our NACM past president. Will?
Well, thank you. Welcome, everyone. It's good to see you all.
Will.
Yeah, it's really good to see you all, and we are looking forward to this great discussion on this topic of diversity, equity, and inclusion. We have a great group of folks here. We have Martin, who's the AOC Director for California, Mr. Roosevelt, who's representing NASDA, and we have Judge Stevens, Michigan, correct? And their bios are on your conference app. So I encourage you to read them and look at them so you know what their backgrounds are, but it's on the conference app for this session. This is basically a continuation of a discussion that we started a year ago, and it's backed by popular demand, diversity, equity, inclusion in the courts, and why it's important, and why should we care. And so what I'm going to do is kind of moderate this entire discussion and seek out the experts' opinions. NACM has started a diversity, equity, inclusion committee, and this past weekend, it was approved to be a standing committee for this organization. So I think that's great news. We're kind of behind, but that's great news that we're taking that step. So, but other organizations and people like Judge Stevens have been doing this for quite some time, and we want to pick their brain, and hopefully you can take some of this information back to your courts to improve and reevaluate how we look at diversity, equity, inclusion in the court. So I will start with the panelists and ask them, starting with Martin, and come on down, why should we care about diversity, equity, inclusion in the courts?
Well, thank you, Will. Welcome, and thank you guys for having me back for a second time. I do appreciate NACM and its involvement and its attention and focus on this particular issue. It's something that we in California have been working on for quite some time, and I'll talk about it a little bit more. But this is the part where I get kind of a little bit dramatic sometimes for people when I frame why it is that we should care. I don't think I'm being very dramatic at all. What I see is a legitimate asking of a question that is really core and important in America, and I'll explain that a little bit. But the question is really, is the judicial system legitimate? And this is important and fundamental to democracy, because in American democracy, it's predicated on this notion that the government can govern with the consent of those who are governed. And if the consent of those who are governed are concerned about the legitimacy of what is happening, this is actually the very core of our democracy and the cornerstone of it. The question, of course, is justice colorblind? We all know the image of the female with the blindfold and the scale in front, but the question is justice colorblind? And can you really have any form of justice whatsoever if there's a question about whether that justice is racial, or whether it's gender, or whether it's by identity of any way, shape, or time or kind? And so again, I hate to over dramatize it, but this is really what's occurring. And the second thing that is very important is the current discussion that is occurring in the energy in this country is not isolated to one particular ethnic group or gender group or identity group. If you see who is getting involved in this conversation and is on the streets actually protesting and pushing and asking these very legitimate questions, it is a broad spectrum of people. And the third point that I would make on all of this is there's also this phenomena of generations occurring in America. In a simple, oversimplified manner of this, you have approximately 80 million baby boomers, a generation that we all know about that's held political power for quite some time and really had control over our democracy. And they are essentially twilighting and leaving the scene. You have a generation that is my group, regrettably only in numbers of about 40 or 50 million, and we kind of look at ourselves as the tweener generation. There's really a bridge. And what's coming right behind us is another 80 million Americans that are called millennials and Gen Zers. And they have a whole different way that they want to see the world. And I will submit to you that this next generation is redefining the democracy that they want in America right before our eyes. And so each of us, who are not just a generation in terms of age, but a generation of leaders in the judiciary of this country, have the responsibility to bridge or to shape and do what we can to help redefine what that next generation of democracy will be. And this question of justice, racial justice, gender justice, and identity justice cannot be ignored. And I do not think this is just a moment, as people describe it. This is actually a movement in the history of this country. And you ought to care about it because, again, going back to this question, if the citizens and residents of this country do not perceive their government to be legitimate and representative of them, then they will change it the way that they want to. And so if you're sitting in one of these seats, you have an obligation and a responsibility, I believe, to make sure that people actually see that their government is legitimate and that you continue to have the consent of the government, and nothing more than the future of American democracy is actually at stake.
Thank you, Martin. Mr. Roosevelt?
I'm going to be melodramatic. You were dramatic. The court system, justice system, is a racist system. It came and it operated under white supremacy. And the reality is that it is a system that's seen by many people as being weighted on whether or not you have money and whether or not you have, you look a certain way to get access to justice. We are trying to change the system from within. And that system is reluctant and resistant to change. It is a very conservative, robustly conservative institution that fights to maintain a certain way of operating. I have seen this system break down judges, cause judges to retire, cause judges to have second thoughts about what the hell are they doing in a system that seems to be populated by people who look like them, black folks who are being locked up. We need to address the fact that justice is not blind, justice is blindfolded. There's a difference. She's blindfolded and not blind. So I'm thinking back to a judge who I met 20 years ago, and she said that outside of her chambers, an African-American judge said what was most difficult for her each day when she heard those chains coming down the hall. And it reminded her of the Africans who were enslaved. And so she's working in a system that's a very robust system that's hard to change. I have to be optimistic, that's why I'm here, that we have to tackle head first this difficult conversation about racism, institutional racism, and systemic racism in our justice system. If we are not bold and brave, we'll be talking about this again when my grandkids turn 100. So I want us to really take a deep look at racial justice in this country and really challenge ourselves to be honest that this system is not working. It has not worked for many people. But the bigger question is, can it work? Will it work in the future?
I like big questions. With all deliberate speed, that's what the Supreme Court said, it seems like 14 million years ago. All deliberate speed meant we ain't changing unless you make us. And I heard our colleague talk about how this is not a moment in time, it's a movement. Well, I'm one of those boomers. I guess I'm about to go stage left. But when I came of age, it was in the 60s. And that was a movement. It moved, it included persons from many different backgrounds, but it was principally a movement that, other than those of us who felt dispossessed, was a movement that was joined by middle class and elite European Americans. And it did accomplish the end of legal segregation. It did accomplish a moment in time where the country, out of pure guilt, said, maybe we can do something different. The problem is, it did not include and did not encompass working class people. And for the last 50, 60 years, there has been a growing anger all over our society. Working class people feel dispossessed and disregarded, see their hard-fought gains in coming toward middle class stability being eroded. And there are those who've played on those fears. We're at a different moment in time, however, because just as my colleague pointed out that they're probably going to put us all in the old folks' room. It won't be a home because this country's too cheap to pay for elder care. But I know, for example, in my jurisdiction, we are going to have a change in 30% of our judges in the next 5 years. And everything I read tells me that's true all over the country, because people, by and large, do not become judges at 2. So we have a senior class of judges who are going to change. And we have a burgeoning class of young people who are not going to wait their turn. And the combination of those gives us a window in time, if not a movement, a moment in time. So much so that with my old self, finally we're going to get a DEI commission in Michigan, which is a state that started the research into race, gender, and ethnic issues and fairness in the courts. But it took us almost 40 years to get to a commission. So I agree that it is a moment in time, but I think it's a time for, you know how AmeriCorps says, let's make use of all those former hot shots at corporations? Those of us who are on the side of justice, not just us, who are aging out, we've got an opportunity. We can do what trial court judges can't do. They've got to, in the next year, our trial courts are going to be overwhelmed with the COVID backlog. And those of us who are moving to another stage in our career, we've got the chance to join with the young people. No deliberate speed, full speed ahead, quickly, solemnly, and together.
Thank you, Judge. I'm going to stay right here. You talked about the commission that was started in Michigan in regards to diversity, equity, inclusion. How did that start? What was the impetus? What made it get off the ground, and why did it take so long?
2 hours? We did not have a Supreme Court that would take ownership of this task. So the diversity and equity and inclusion work, the recommendations that came out of our race, ethnic, and gender bias issues in the courts task force in the 80s, sat with the state bar. State bar is a wonderful thing. I was a commissioner forever. I love it. But the state bar is not in charge of one court of justice. And so despite the fact that we had many chief judges who were fine human beings, none of them took this on. So what happened, and it's hard to say this, and I hesitate to say it, but the bodies began to pile up at the courthouse. And when George Floyd's body joined on top of Philando and Sandra and everybody else, even stolid, careful courts thought they ought to say something. And our court said something. And it could have stayed right there. But you have grumpy little old people like me who said, okay, now I heard you, but I don't really hear you. I don't hear you unless you do something. And we were able, through our new Chief Justice, to find someone who said, okay, I'll do it. I'll step up. What's the worst that's going to happen? People won't like me. A whole bunch of people don't like me already. And so in that moment of time, we were able to take advantage of it. And I so urge people, to the extent that your funders, to the extent that your constituencies and some of your stakeholders are feeling the reality of systemic racism and systemic instability, because that's what this is. Our justice system is unstable. And to the extent that you've got allies who feel that way, push them beyond their comfort zone. what a pushy little old lady would say.
Yeah, thank you, Judge. Straight and to the point. Michael, what has NASDA done, and is there any significant changes or things that took place in your organization in regards to diversity, equity, inclusion?
So NASDA, for those who don't know, is the National Association of Judicial Educators. It is an organization that's founded and focused on the 58 states and other 50 states and other territories that provide judicial education. And so it plays a central role in our justice system because it educates the court staff, the judges, the court administrators in their various jurisdictions. So it plays a key role. One of the efforts that we've undertaken, and it's been slow moving, is to diversify the profession of judicial educators. When I came into the place 20 plus years ago, I was the only African American male judicial educator in the country, okay? Today, I am probably one of 4 African American men in the country who is engaged in judicial education. So we've made an effort to do more education and outreach and mentorship to support the profession. It's a challenge, it's work. I have to say that the people who are in the organization are committed to diversifying the profession. That's a really core value because most people don't know the profession even exists. So we have to educate them that it even exists so they can actually consider being in judicial education. The other ways in which we have been very active is really building up the profession and giving them the skills to have those difficult conversations about race. So regardless of whether or not you're African American, gay, lesbian, whatever, we want you to have these difficult conversations about race, gender, sexual orientation, and we're going to give you the tools so that you can be effective at delivering those programs. And so we see ourselves as nurturing and supporting individuals who are doing this kind of work. We've expanded that to talk about, we know you can't do it, but how do you determine who are the best faculty to deliver the content that you want to present? In other words, you have to have some fidelity to your model. You can't have everyone who has a shingle out saying they do diversity and fairness training do your diversity and fairness training. I call that malpractice. So you have to have some quality control. So we've been working very, very hard at finding people and resources to connect people to resources that I think will move this conversation forward around the issue of race. Most exciting, I'm working with a project right now at the national level. You may have heard of it. It's called the 21-Day Racial Equity Challenge. How many have heard of it? Okay, there's a few people. The Racial Equity Challenge is an exciting opportunity that you can engage in self-study and group discussions in this area around race. And so we're now building a resource for educators to have their own racial equity discussions over a 21-day period. And so we're working with the person who actually created the original 21-day solution, and we're going to launch this in October at our conference that's going to be in Connecticut. So come on to Connecticut. That's where it's going to be. And so I think there are some concrete things that we are doing at the national level, but I think it's important for judicial education to understand is that we are in partnership with National Center for State Courts. We're in partnership with all of the ABA, the local bar associations. There is a partnership. So having said that, educators realize they cannot do it alone. And so we need a system to support the efforts to expand and to create, I think, the kind of education and the kind of practices that will move us toward the future. So hopefully that gives you kind of an overview of where we are and sort of where we're headed.
So Michael, you talk about the 21-day and Connecticut. Will this be recorded? Is this something that court professionals across the country can tap back into if they're not there?
So we're just getting started. But I'm optimistic if we create a successful model, we're going to be piloting it with within our own group. And we hope through discussions with our own group, we'll be able to say, okay, you take it and tailor it to your own jurisdiction. Because we don't think we have the answer. We think we have one of the answers. And so let me explain the 21-day. That's what you're really asking. Yes. So think about it this way. 21 days, and each day you are either reading, watching a video, listening to a podcast on a particular issue. So let's say the one is on allyship, how to build allyship and collaboration. So you spend a whole month reading each week some of those on those topics or watching a video. Then after that week, you have a month, you have a discussion with a facilitated discussion with a facilitator. And then they sort of have you dig deeper in that discussion. So it's a group discussion. You dig a little bit deeper in that discussion. And then you come out of that and you do your next series of readings and videos. Let's say that's on white privilege. That was an example that was used, that we've been doing. And so we move through it. I'm giving you what the other curriculum, that's not what we've done yet, but we are going to probably have some of those elements in it. And so it is a kind of, or very practical way to have these very difficult conversations, but do it in a supportive way. Let me say to you that I'll give you the person who actually created the model. His name is Dr. Eddie Moore. He actually created the 21 Racial Equity Challenge. If you want to go on the ABA's website, you can see the ABA one, which is available and you can do it, but it's designed for lawyers. This is something we want to have more tailored. So I hope I gave you kind of a brief overview of what it is. Now, will it be available? I have no chef secrets. If you want it, you can have it. So we want to make this thing available to everyone for your own adoption, adaptations. You can toss it out and start fresh. It is simply a model that one could use.
Thank you. That's very helpful. Martin, I know California has done quite a bit in the area of diversity and inclusion. Talk to us a little bit about what you have done in your state in this regard.
Yes, thank you, Will. I'm happy to do so. And I brought along some slides to share with people. And I want to unpack these a little bit with everybody, just in case this question would come up. And before doing so, though, I want to get to a question in front of that. If I could redirect it, apologies. If I go on too long, cut me off, intercede. But what I want to talk about are the things that we're doing, which blows past this other question that comes up that you may encounter in your own world, which is what should courts be doing and what can courts do, given this notion of the judiciary, the standoffishness, the grip that Michael and Judge Simmons is alluding to, of the unwillingness perhaps to change. And sometimes there is this veil of ethics, this veil of these canons, these pillars. Well, that's not really the proper role of the judiciary. And that conversation is occurring in California. In talking to my colleagues around the country, it's going on in every particular state. There's a fair question to ask of, well, is this really just the fear of engagement, or is it really just the continuing grip and unwillingness to advance the level of change? And luckily you have pushy folks from other generations who might lean in on a new generation to say, oh, no, sick and tired of being sick and tired. Time to start moving this show along. But the point is one thing I would submit to you and that you can take back is, as you're dealing with this question of what should happen, maybe it's just as simple as what you have to actually do. If you think about the fact that the judiciary cannot escape its proximity to the criminal justice system in every state and in any country, you just cannot escape it. You may have alternative solutions for other types of matters that get adjudicated by a court system, but that one is inescapable, and you can't get away from it. And when you finally accept and become aware, and everybody becomes aware and understands that it's a given, that the criminal justice system is institutionally and operationally racist in America and in every state because of the passage of time and the things that have been held there, that's just where it is. I ran the prison and parole system of California for quite a bit of time. And I was there when we were reforming and reducing the population by over 60,000 inmates and 100,000 parolees. When I arrived, 80% of the people in California's prison and parole system were people of color. After all of those reductions, 80% of the people in California's prison and parole system are people of color. In 1974 in this country, 34% of the people in prison, this is 1974, before the big dramatic changes in ISL and DSL and the like, 34% were Black Americans in prison. Today, across the country, 34% of the people in prison are Black Americans. That is way out of step with proportion. So there's been efforts to reform and change. And what I'm building with this is because of your proximity, you can't actually escape it because you're part of that system. So if people are hesitant and wondering and talking about ethics, there's just some flat facts you can't ignore. The other fact, I'll just restate it, you already know it, and then I'll dive into California, is that 95% of the matters of justice in this country are adjudicated in state courts. That's the size of the footprint and the impact that the judiciary can have in this particular area and on this particular initiative and this particular need. So let me get to California. Sorry, Will, for doing all of that, but I was trying to tie it between the very powerful question that you started this with. But this is California. And so what started quite some time ago, so this is not me, this is really me reporting the work of people that have been doing this for about 20 years or so, and this is the point in time of where we are. These are people that Michael Roosevelt know, judges that I've already referenced, that really were the leaders in this area. But what we started to do was actually collect this data, and I would suggest that you go to our website, and I'll give you the link in a second slide or third slide here, to start to map and think about, can you do this in your own state? And this gets to the issue of the pipeline, and it's on the very first step. And what we do is we take the state population, which is the first pillar, then the law students, who's in law school, then who's an active attorney, and then who's actually on the bench. And we categorize it, of course, by race, and then, of course, we're tracking in terms of gender, LGBT, disabled, veterans. And by the way, we use a model of self-reported information. Some folks will use observed information versus self-reported. That's another footnote for you to be aware of. But what this is how we are checking ourselves to see how we're doing. And we thought, hey, this is very, very, very revealing, and we see how we are doing in terms of a state. And it also, what it does is it forces data transparency, and it creates a whole nother set of questions, which is, well, what's going on in law school? Are the admission practices that are occurring, right? And this is the pipeline that everybody talks about. Well, then once they become law students, who can pass the bar? And then as they're passing the bar, then who actually, right, is active and sticks with it? In California, it's a 10-year requirement before you can make the application for the bench. And so this is how we continue to track it. So we feel good about certain categories at a state level, but then we don't feel good about certain categories, as you can see at the state level. California being very unique and obviously having a very large Latinx population. We're obviously way behind in all of those categories and have a lot of work to do. But even in the category of African American or the category of Asian Pacific Islander, you could say, well, doing a pretty good job at the state level, but it's misleading. Then what we learned is, wait a minute, California, just like all of your states, has urban settings, suburban settings, and rural. We still have a regional problem in California, a dramatic regional problem where you say, well, you can't say, well, we're okay on African Americans. Actually, we're not. If you look at a certain region or a certain city or a certain county in the state, we're actually not. But in some, yeah, we are. Anyway, the point of this is to continue to track all of these things, and we wanted to put it in just one simple graphic, try to get to the picture that can tell 1,000 words. Second slide, please. And then up front, again, the real moniker is called Pathways to Judicial Diversity, is one of the big efforts that we've been putting in. And it's so important to get the leadership buy-in that Judge Simmons was talking about at the very top. So we get our California Supreme Court justice to step out on this particular issue. And then similarly, in California, the governor does most of the appointing. Very few of ours go to election. And I know at some states it's by election, but we wanted the governor's appointment secretary also to be part of this initiative, and we are working very closely and continue to work very closely with the Newsom administration on this. Next slide, please. And then this is actually the link. So if you can take a picture of it, or it's not too hard to find, or I'll leave it behind like we did at the last session, just go there And each one of those 4 buttons, actually, if you click on those buttons, it will open up gates to all kinds of other links and ties, from law schools to the mentoring program, which now the governor has done, in our state has done a big press release on, and all of the things that you can do, and it ties you again to the bar associations and the like. And I would encourage you to go there, and like Michael said, there's no pride of ownership. I would steal often and shamelessly from this. And take ideas back to your own state. And some of them will work and some of them won't. You know your environment and you know where you work better than us up here. But you might be able to cultivate a few ideas here and there in order to percolate and make suggestions as these forums and these questions come up. And so I'd encourage you just to figure out, well, which pieces may or may not work, and go forward. And then the last slide, please. And I can stop talking. This is kind of where we're at right now in our desire and our quest to have a bench that reflects the diversity of the state, and so that the communities actually see themselves there. The judicial administration standard, this is a big deal because now it's using community outreach as that official judicial function, not just well, we might want to do it, we might not want to do it. Again, it goes back to if 95% of the cases in this country are adjudicated at the state level, then you can make a big difference, but you got to make it official. Obviously, everybody with the partnership, state and local bars, as well as the law schools. And then these are the diversity summits that I was alluding to. This has been going on since 2006 in California. We're up to our 4th that we're on to. And then because we've discovered the regional problem, are going to different regions around the state now to extend the outreach and the diversity of summits, actually putting them in the areas where we're having some of the imbalances. And here's the proof in the pudding. Because of the work of folks a generation before me, and hopefully continuing through me and onward, you can make a difference. So because of all of these efforts in the generations for which Michael has been a part of, the actual diversity of California's bench has increased 50% since 2006. Now, even saying that, if you think about the first slide, you can still see even with that is not enough to celebrate. We have a long, long ways to go. So, Will, thank you for the opportunity I'm not trying to boast or crow about it, but just simply share what can happen if you have this will and this capacity and this leadership, and you sustain the energy in much of the structures that Judge Stevens was talking about, as well as the establishment of DEI as an official formal structure, and the things that Michael is talking about in terms of educational programs that aren't just a one and done scenario, but they just keep going and they live on.
I have a question for my colleague here. How do you sustain that momentum? Because it's been a long haul to work toward diversity. And sometimes it's the same people who are leading the charge. How do you get new people on board to sustain it and support, which I think is a Herculean effort? So I'm just curious.
No, I think it's a powerful question, and it's a completely legitimate, and it should be really as simple as a matter of establishing structures. Mm-hmm. Because the players, right, they come and they go, and the truth is we all stand on the shoulders of a lot of champions who grab an issue, and it's not just unique to this one. If you think about collaborative courts, mental health courts, right, substance abuse addictions, drug courts and the like, those were because you had some very passionate, strong-minded, forward-thinking people that started to establish those things. And it was the structures and the policies and the education and all of those features that have to come along, the rules of court, right? These are the things that are necessary. That way, it's not just determined by the strength and the generation of the people. And we're dealing with this in California. We have a generation of judges that have ushered in a lot of great things. They are very worried that, I have to clean myself up here because I may be actually a boomer, but I choose to define things, but they may be the party, and they are understandably very worried about whether or not things will actually be sustained. And they're very honest about it, and they're very candid about it, which is the heart of Michael's question is, you have to start to now build in the structure and the formality of all this and stay on it. But you're still going to need those leaders.
Yes.
But building a structure that isn't supported, one of the things I think that you talk a lot about mentorship, okay? I used to have a philosophy. when I first went on the bench, which was 39 years ago, we could count all the black judges, pretty much all the black lawyers, most of the women. In fact, we used to always meet together to have lunch, and it wasn't a big lunch table. But one of the things that I took on as a responsibility is I had to introduce people to new black people. So I would agree to a committee or a commission for 5 years, and I would groom a replacement. And where do you find your replacement? Well, you find your replacement with a young person who's in undergrad and is in the pre-law class. You find your replacement for the person who says they want a judicial appointment. You find your replacement in places where they're developing their career. And to the extent that we have these structures, okay, you've all participated, I think, in the great appointment competition. There's some hoity-toity commission, something that's supposed to be very influential, and people call for nominations, and there are 152 people that apply, and 3 of them are going to get picked. So what happens to the other 148? The idea is, with our commissions and our structures, to provide tentacles and work groups, smaller work groups, just to work on a task, one task. And if the person doesn't show up, then you know that, you've learned that. But if the person shows up, 4 more people know that person than who knew them before. And that person has had a sense of success and being valued. So this is a marathon kind of effort. And anything that you get into, realize that you're going to have to be able to plan for somebody else to take the next lap. It's not an individual marathon, it's a marathon relay.
I'm so glad you said that, Judge. One of the things I mentioned to the board the other day was this is like a living document, this diversity, because it continues. It's not a one thing that you can do and create a resolution and just let it stop there. You have to keep going. So as an African-American judge from Georgia and now in Michigan, I think what you see in this room is a cross-section of the entire country of different courts, small courts, rural courts, middle-sized courts, large courts. How do they have a conversation with their judge about what may be missing in regards to diversity, equity, inclusion in their courts? You're a judge. What can they take back to get that conversation started? And I'll go down the row here.
All right, so he's asking you to go to your boss and tell your boss that they messed up. He was being very subtle. I don't do subtle too well. Okay, and that's a risky thing, okay? Because you really do, your kids need to get their braces, and the dog needs dog food. So you do want to maintain your job. And so what I suggest to you is frame the subject after collecting the data. If you come to someone with an objective fact and say, gosh, you know, we did this and we see this. How can we fix this? Can we agree that this is not what we want it to be? And then secondly, figure out who else has an interest in this who is not quite ready to throw a flame. I was the kid who, shut down with a bunch of other people the University of Michigan. You wouldn't take me to go visit your judge. Not at 19. But at the same time, we had a dean of the medical school, oddly enough, at the University of Michigan, Dr. Albert Wheeler, who is also a city councilman. So I could take Dr. Wheeler with me to go talk to the judge. He is an individual, and that's another use of a fairly antiquated generation. There are people who have long-term commitments and who are willing to go with you, and maybe even go before you, with this objective phenomena and have a conversation. And realize that I believe in transparency. I love transparency. But I have curtains in my house. And I have curtains in my house because there's some things that are ready to be seen sometime and some things should never be seen. So I say that to say that it's an internal conversation. It's not a conversation with the Atlanta Constitution or the local newspaper. But start with data, look for an impassioned but rational ally, and then have a private conversation and move from there toward better.
I couldn't say it better. Data really can drive your decision making. And I think that if you have good data, but it's important to have data that's just not number, but it's visual data. People can actually visualize the data and see where they fit. So it's a conversation that they have about the data, and it's a conversation that they can actually envision something different. Sometimes data can look like flat on the page, but it can give you a kind of a guidepost, a direction about where you want to go. When you have these conversations, I always default to humility. It's always more about the inquiry and asking the other person more. Here's some information. I have some thoughts about it, but I'm not sure if they're correct. What are your thoughts? I mean, you really want to engage in a conversation because some people often think that if you have an agenda, they're going to be against your agenda. So some ways in which you can have a conversation in a way that pulls them in. Every individual or group you talk to, as you well know, is different. So study the group before you go to the group. Read the room. Don't assume because they look like you, they think like you. That's always a very big mistake you can make. And so read the room. And if you're real smart, seed the room with people you want in the room who are going to support you and back you in that dialogue. It was so interesting. I did a session this morning, and I gave like 4 hugs. I saw people that I knew, and so I knew if I got stuck, they were going to say, oh, Michael, by the way, So you really want to seed the room and really have those, what I call difficult conversation. But I always try to enter it with humility. Point of disagreement, but subtle disagreement. Sometimes you need the fire starter. Sometimes you need the angry black man. Sometimes you need that to push people, but it has to be strategic. You can't be yelling all the time.
And it depends upon when.
And you nailed it. That's my point exactly. Sometimes you need that person in that dialogue to shake people up. So I'm going to give you an example. I'm going to shake things a little bit here. We're a good-looking panel, but we need a white person here in this conversation. Because you have to see yourself in the conversation to be a part of the conversation. And so I'm not saying that as a token, but I'm saying that in terms of communicating people who are on the fence, who turn off when they see just people of color talking about this stuff. And so I'm having that difficult conversation about who is missing from the conversation. Is part of that humility. It's recognize what you don't know and who is there who can enhance that conversation. That's difficult.
So when we were moving first to our DEI committee and then on to our DEI commission,
Right.
The conversation I had with the chief is I said, I won't do it unless you find me a white man.
Mm-hmm.
And she was like, well, where would I find one? I was like, I don't know.
Look around.
No. But,
Is it really that hard in Michigan?
yeah, well, one would think it's not. But the idea was one who was predisposed
Right.
to
Yes.
Right.
engage
yes,
in the
yes.
conversation.
Right,
And
open-minded.
I did appreciate the challenge, but I was insistent on that. And there are times, there are different scenarios and different conversation, and the conversational group changes.
Mm.
Because I'm going to tell a secret. Not all the black people are with you. Not all the black people are with you. Skin folk ain't necessarily kinfolk.
Right.
There is diversity of opinion. within every community. And coming to, I'll give you an example having nothing to do with race. I went to a sorority meeting. Which sorority? Delta Sigma Theta, thank you. But it didn't really matter. It could have been a Lynx meeting. It could have been a meeting of the Eastern Star. I went to a meeting of a group of women who were all educators or who had advanced degrees. And so we started talking about the vaccine. And I discovered that 3 of the women out of the 10 had decided they didn't trust the science. I would have assumed, to my peril, once the restaurants were open, to get together with my girls, have a glass of wine, unmasked, because I was making an assumption that people who looked like me and shared some demographical characteristics thought like me on crucial issues. And that's one of the big things. You don't know what people really think. And the only way you know is if you listen more than you talk.
Drop the mic, Judge. So Martin, same question for you. You talking to court professionals from across the country. How do they get the conversation started with their superiors or chief judge or director or whomever?
It's hard for me to add to the solid advice from the other 2 panelists. Maybe I just might do it in my own version, but in teasing out and putting more framework, dead on, know your audience, read the room, know who you're talking to, make an effort to study that person. And what I mean by that is not the person per se, but because it's a professional setting, what is on their agenda? What can you learn that is important to them already that's baked in and built in? Because that's the easiest path. And then how do you bootstrap, right, what you want to talk about and what you want to propose to something that is already important? It's what I do with, frankly, every public official that I meet, and I'm trying to figure out how to push reforms or make things change, is to find the natural path first that's built in already and baked in. And then, same advice from them, build your coalition of the credible and the willing to come along with you so that you're not the only voice. And then the simplest rule for me is, and this is the way it is and when I run all of my programs and operations, is you don't get to bring a problem with your data.
That's right.
Unless you bring a solution. Because the best way to have it all fall apart is to get attention because you're routing it, but you don't actually have an answer. That is by and far, and I can just tell you from the corner office, if it speaks for a moment, that is the biggest turnoff in the world. I mean, that's just blowing the opportunity, and that was taught to me as I went through job after job after job. So just all of the things that they framework. And since we're just going with the flow here, not everybody's with you. So in real time, the conversation in part of my Asian community, because of the rise of Asian hate crime associated with the pandemic and the other things, is a very difficult and complicated conversation about, should we be saying something? Are we allowed to say something? Right? Because every culture has its built-in, baked-in set of norms. You know, the angry black man, is the angry black man allowed to be angry and black? Is an Asian man allowed to be angry and Asian? Maybe, maybe not, but that's not what people would expect, right, from the Asian culture. But we're having this difficult conversation. Sort of the generation underneath me is, why are you so quiet? Why haven't you? Because telling secrets, we're having this thing of, well, I mean, are we really allowed to? That's not really how we were raised. That's really not who we are. Or is it how we are? Or is it how we should be in this particular moment? And since we're telling secrets, the conversation I was having with my boss, the Chief Justice, she found, this is a real conversation that we had night after night after night. She makes a decision to make a public statement. And she goes out and she talks about how it's personal and how it connects with her aunties and her uncles. And I should have brought it with me, but if you're ever curious, the cute secret here, and it's not cute, it's actually kind of cool, is her statement is actually written in the same pentameter as the Tao Te Ching
Wow.
when it gets to the
deep.
rule of law. I know.
That's deep. That's deep.
That's her.
That's her.
But anyway, it's a fascinating time, and I'm just kind of going with the flow. But it's to the point that the other panelists are making here is don't be so sure that everybody's with you. So when you're marching into this, because again, my chief is out there now on this particular subject and staked her spot in the ground, but behind her, there's a discussion going on in our community of, well, maybe that wasn't the right thing to do, or was it? But again, she's the leader, she's the
Yes.
chief, she made her call, and off she went. But I wouldn't say that all Asians are there.
Yeah.
It's a great discussion, and so I like our being candid this way. So that's why I didn't want us behind a table. I wanted us to engage, so that's why I wanted this format. So we're right at an hour. I want to give people an opportunity to ask questions because I'm sure that you all have questions for these three experts here. But before, Cheryl, you're going to pass the mic, I think. Let's give our court managers from across the country an opportunity to ask a question of the panelists.
Good afternoon. Thank you for this topic. I'm Melissa Chengary. I serve as the Clerk of Superior Court and Judge of Probate in Charlotte, North Carolina. We have been doing a lot of work that has been steered by court leadership around racial equity. Our Chief Justice was the first in the country to speak out about the intersection of race and George Floyd and the civil unrest that we were seeing. My question or comment that I'd like you to speak to is something that I will call black fear. Justice Sherry Beasley was unseated after making that comment, and series of comments and putting race on the table. We have other judges who also lost their seat as it relates to redistricting. When you have followed that trajectory to get to a judicial position and you are a person of color, and it is a seat you want to maintain, it is your life's goal, how do you manage being able to speak out about racial equity and maintain the platform for which to have that conversation?
Okay. High heels on a tightrope? I am a person who runs for election, or who used to run for election. No more. And I ran in 7 counties. And in the 7 counties, there was a minority population of 14% in one county and 40% in another, and occasional visiting black people in the other counties. So I'm familiar with running in interesting places. I'm not going to tell you that it is easy. I'm going to tell you that your aunties are going to call you, and if your grandmother is living, she's just going to show up. My grandfather said, a jealous man can't work, and a scared man can't gamble. You're either going to live your life or you're not. And on what terms you can do it, you know. Unfortunately, whereas 20 years ago, the people who got to the bench were people who had deep-seated community roots in about 4 million organizations. We're in an era now where the persons who are selecting people are selecting them not because of their commitment to a community, but because of some other factors. So these people who are maybe very, 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 very fine judges don't have any community backup. And so I would say to people who feel compelled, gather your troops before you open your mouth, so at least you know what support you have. And realize that every now and again, I remember getting an editorial. I was running for a statewide office, and the night before the editorial was, 2 days before the editorial was supposed to come out, there was a gubernatorial order that had been issued to close our mental health facility. And they had decided, and they kept putting it off and putting it off. And then, for reasons that I can't explain to you, they decided they were going to move mentally ill people at 9 o'clock at night. I got a request for an injunction. I'm clear, sundowners affects even the elderly who are just suffering from aging. Persons with serious mental illness, which is why they were there, do not need to be moved at 9 o'clock at night. I issued an order, just said, move them tomorrow. I got nasty editorials for a week. Not a black lawyer, not a white lawyer, not a union, not a healthcare professional wrote a response to the letter to the editors. It was hurtful, but again, quoting my grandfather, just scratch and get glad. You just get over it. It's the best you can do.
May I say something, please? Yes. Getting old is hard. My name is Lawrence King. I'm a judge in Arizona. I'm also a tribal court judge, and your California thing has a little bit more than 23 judges. Hi, Mike. How you doing? What you just said is correct. Now, the unfortunate part is that I'm sitting here with court administrators, nothing wrong with that, but I just came back from my judicial conference where I'm now tasked with diversifying our bench because we don't have it. People are going to shoot arrows at me. So what? I'm big. I'm chubby. And if I don't become a judge next year, I did what I needed to do. But I'm going to leave a legacy that there are going to be some more coming up along that path. And I would implore everybody to do exactly what this panelist has said and bring it back. And if you have, your bosses, your judges that you go to, the data helps, but, they got to do it because this is what America looks like and this is what the court's going to be like going forward. So keep up the good work. And if you need a judge to blame me. Okay, go from there.
Thanks,
we have
Judge.
a question from our online audience and asking if Michael could repeat the name of the 21-day challenge, the
Yes.
complete name.
It's somewhat different names, but the 21-day Racial Equity Challenge. 21-day Racial Equity Challenge. If you just put that in a search, it'll pop up for you. If you put down Dr. Eddie Moore's name, then you will find his website and information about the different versions of that project.
Hi, I'm Misty Robinson. I work in Pierce County, which is, the county seat is Tacoma, Washington. Question for you about mandatory versus voluntary education. Maybe Mr. Roosevelt, you could answer this question. Not in my current court system, but in previous court experience I had, when there was education on diversity, racial issues, sometimes there was outright pushback on that from staff members. The approach I've taken in my court is to have education be voluntary, kind of with the correct assumption, I don't know, that the right people will show up, that if they're truly interested, they will, the right people will be there. So I'm just interested in your thoughts on that. Maybe the old saying that you can lead a horse to water, but you can't make them drink. So just your thoughts. Thank you.
So I'm going to also ask Martin to weigh in on this one as well, because I think California has some particular focus on it. There are required education programs for judges that they have to go to. I mean, they are required before they get on the bench to take a series of, we call it new judge orientation. It's called different things in other states, and it could be a week-long program. They're required to do that to become a judge. When it comes to diversity and fairness topics, there's often a resistance to making that required. It's sort of like a thing that would be nice to do when I have more time, but it's not the law, right? It's not the law. And so I think what has been missing in judicial education is a history of race and the justice system when they get on the bench. In other words, part of their orientation is revisiting all deliberate speed, backtracking with judges in particular to kind of say, let's talk about, before you get on the bench, here's some history. There were lynchings on the courthouse steps, right? I mean, you need to go back, since you got them, they're a captive audience, right? The other thing is that around mandatory education, it's how it's framed and how it's phrased, right? You can say it's mandatory education, people will get all resistant, to it. But if you say it will protect you if you come into an ethical situation. In other words, if you do this, this means you're not going to run into these kind of issues in the future. In other words, it's kind of like your protection, your shield of protection. If you go through this training, you're going to be protected in some way from any kind of maybe saying to the Commission on Judicial Performance or some kind of hammering in terms of your performance as a judge. So I think that's on one end. For staff education, it's a little bit easier. You can require it, and I think mandatory in some cases needs to be the language that you use. But it's important, if you can require it, they can still go to sleep while they're in the room. They can still be inattentive. But I think you have to make that a part of their performance evaluation. You can't make that outside of it. You say you can go, but this is part of the performance evaluation. And you'll be asked and you'll be looked at in terms of whether or not this is part of your job performance. You got to have some meat attached to it for them to know that this is related to my job. So those are key things. I find often court staff are more willing to be adventurous and try different things, at least one time, right? And so you have an audience there that's more likely to experiment or try. So I am of a belief that there needs to be a mandatory core and an elective core. And those things that are mandatory, but there is a certain expectation that there will be a level of accountability, and the performance review will reflect whether or not they participated and what level they participated, and those are the kind of things that I think I'll be looking for. And you can talk more, Martin, about California, because there's a lot of things going on in California right now.
Yeah, but I want to be brief because I want to permit more time for all this. But I nod my head here, a lot of agreement with Michael. He made a good distinction between judicial officer education, court staff education, and also the distinction between what's elective and what's mandatory. And just to underline a little bit of his point, when things are mandatory, sometimes what happens is you get people and you close their mind right away. Mm-hmm. So when you have a particular sensitive subject, it can be difficult and they dig in right away. Like even today, there are some people who just are unaware of the version of history we've all grown up on or been taught in America. And so this big debate is going on right now, and it's manifested in the critical race theory discussion, right? But we've all been, right, because history is written by and then taught by the victors and the winners, right? But we don't tell the American history, which in the short, pithy version would be, well, it's not a nation of immigrants. It is now, but it actually was a nation of colonizers, right, enslavers, right, conquerors, yes, and then immigrants. But we don't tell that version of it, right? We start with the other version that we all grew up in, and we're all part of that. But that's not actually what happened here, right? But you get into that truth-telling piece of it. But some people don't buy into that, so how do you approach them? In California, when mandatory training came on and was imposed from the state level in the organization that Michael and I worked to, there was actually the beginning of a revolution. And Judge Armstead may have been here when that happened, and Mr. Roddy and others that are here from California. Big thing happened. And so there was a reticence to step away from mandatory. It became more of a slow creep. But here we are, passage of time. There is now mandatory implicit bias training is our first foray back into that. And I'll just be candid. It was an opportunity of, look what's happening. Who in the world is going to come out and revolt against that, given where we are and what we're doing? So it was a bit of a political calculation, but we think the right one at the right time. And so there's not a one-size-fits-all, but the general parameters that I think Michael mentioned are a really good thing to take in consideration. And here's someone who has gone through a lot of judicial education and probably provided a lot of judicial education.
A little bit. What I was thinking was that just as you talked today, Michael, about doing a race impact, that what we're looking to is to make an evaluation of every judicial education course as to whether or not it addresses the DEI component of the subject matter. And with staff training, the reality is these are people who are really not being paid that well to deal with people who are unhappy. Because except for adoptions and people getting married, nobody comes to court for fun. So what we've also been thinking is to make use, almost like a morbidity and mortality conference in a hospital. Look at situations that have just gone wrong in the court and afford the court staff the opportunity to do a postmortem, to come up with some other ways of dealing with that difficult person or that situation that went completely south. And in that regard, you can give court employees better tools to manage their life and still accomplish the purpose. That would just be my suggestion. And that we need to stop thinking that grown people want to sit and have somebody talk at them for 45 minutes. We're no different than children. I had 3 children who were in Grammy school this year at my house on computers. I score more than they did.
Right.
It's just not fair. The way in which we've historically done judicial education is to assume that judges are going to sit and listen to you talk to them. And we're not gonna. We're used to telling people what to do.
Yeah.
So the modules also have to change.
I want to add something.
So do I.
So one of the things that in judicial education, we work around what we call a circle. It's a sort of a circle in terms of how we look at learning. And one of the core elements is that we believe that education needs to be interactive and engage people around the cycle. And so if you were in my session earlier today, I had people doing something. You know, we didn't just talk about the tool, we had them practice the tool. Because what we've learned is that if you actually practice something, you actually end up doing it, right? The other thing that I think is really important, if you come to the NASDA conference, you can learn practical strategies to create interactive and engaged content from national experts throughout the country. And I'm going to give a plug, because I have to, is my, I don't know if he's here, Dean Aldana, is he here? From the National Judicial College. They do outstanding work in faculty development and teaching people these practical skills to enable them to be exemplary teachers, instructors. They have judges teaching judges. They have knuckleheads like me teaching judges. But they actually do some really good work. I'm going to pivot to California because I think, in answer to your question about how do you engage the learner, I think California is doing some very compelling and interesting things too.
Yeah, let me just do this. So, because I wanted my turn back to also probably make a plug.
You're good for it.
Was it, back to the points that were being made on another answer to the question, which is about the credibility of the presenter and how important that is for that kind of empathy and that kind of connection. So in California, there's a big deal, and Michael knows as well, we've organized around judges teaching judges, right? Not so much someone who's not a judge or a lawyer to a judge, but even that still makes sense, but it's just because of some of our history to get over. But by far, we had a gem in our ranks in the judiciary who we thought on this subject, there's not going to be anybody better. And she helped build it for us, and she's sitting right over here, and it's Judge Songy Armstead.
Yes.
We lost her to Los Angeles because that's how passionate she is about this subject. She wanted to be liberated from the restrictions of a black robe. And it's now there, and she's an incredible asset. And you're going to hear from her, I expect, as of my understanding, before this conference is out. But anyway, again, she's someone that we thought, okay, this is who the judges will respond to, respect to. It's not going to work coming from me. What do I know? It's not going to work, right, coming from another staff member or one of our psychologists. It had to be that secret handshake of the credible presenter. And now she's incredible in so many other ways and forums along the way. She can do it, I think, for judicial officers. She can do it for court managers. She can do it for everybody. But that was kind of the point that I really wanted to make, was what my other colleagues that have already talked about, which is the credibility and the connection, especially on a subject like this.
Awesome. You know, Jude, I think you got to bring us back for step 3. I mean, back by popular demand again. So I want to thank. No problem. Okay, we'll be in Washington next year at this time. But I want to thank each of you on behalf of NACM for lending us your expertise and your time on this very important subject of diversity, equity, and inclusion. And I think we need more discussion. This is not a one-time thing. And so I hope that the Education Committee will bring us back. And that's all the time we have. We're right at our closing hour. So thank you very much for attending.